So we have been fortunate that the three members that are here today have accepted to come. They are friends of kings in some ways, they're friends of the FDI Moot. Chairing is Wendy Miles. She's the global head of arbitration of the London firm of Boy, Schiller, and Flexner. And she has a vast experience in international arbitration, including investment, public international law, and exit arbitration. The two members of the tribunal are Sam Wordsworth. He's QC, as well as Wendy Miles, QC. He's a barrister here in London, Essex Court Chambers. Sam also teaches here in the faculty a course on international investment arbitration. In fact, he's been doing it for a long time, a very long time. And we are very appreciative of that and very kind that he still does it. And the other member is our very own Dean of the law school, the Dickson Poon School of Law, King's, Professor David Caron. And he also has, both have experience in international law, particularly in investment arbitration. David particularly has been a member and a chair in investment arbitration cases. Glamis Gold, for example, just to cite one. And so they are going to be your final tribunal. And I then give the floor to Wendy, please.
Thank you. So welcome to the parties, counsel for the claimant and counsel for the respondent. Perhaps counsel for the claimant, Ms. Mulia, could you please outline any procedural timing schedule that the parties have agreed between them?
We have agreed that the respondent would begin first with jurisdiction. As regards the time, perhaps they could.
We would like to allocate 10 minutes.
Thank you. In response?
We would like to allocate 15 minutes and 1 minute for our rebuttal, following the rebuttal.
We would like to also allocate 1 minute.
Thank you.
And then the claimant would follow with the arguments on merits. And we allocate 17 minutes for our arguments on merits and 1 minute for rebuttal.
We also allocate 17 minutes and we reserve 2 minutes for rebuttal.
And lastly, the claimant would begin with on the issues of remedies, and we allocate 4 minutes for our primary pleading and 1 minute for rebuttal.
We would like to allocate 8 minutes for remedies and 2 minutes for rebuttal.
Okay, thank you very much. So if the respondent, first speaker, I understand, Ms. Ipulu, would you like to start, please?
Good afternoon, Madam President, members of the Tribunal, learned counsel for claimant. My name is Marilena Chrysanthekopoulou, and along with my co-counsel, Ms. Despina Arslanidi, we will be representing the Republic of Barranquilla, respondent, in the present proceedings. Members of the Tribunal, it is our submission that this Tribunal lacks, and in any case, it should not exercise its jurisdiction. We submit, first, that the BAT has been automatically terminated after the party's accession to the European Union in 2004, and second, and only in the alternative, that it was terminated by the mutual consent of the contracting states in 2008. Now, in the unlikely event that this tribunal finds jurisdiction, we would like to request the suspension of the proceedings pending the official outcome of the infringement proceedings against 5 EU member states on the issue of intra-EU BATs initiated by the European Commission in June 2015. Beginning now with our first submission, Members of the Tribunal, since 2004, both Barranquilla and Cogitatia acceded to the European Union. And as a result, what we have here is a clear-cut application of Article 59 of the Vienna Convention, which refers to the termination of the treaty by the conclusion of a later treaty. Now, according to the provision of Article 59 of the Vienna Convention, the two successive treaties need to relate to the same subject matter and present a degree of incompatibility to their provisions. And in fact, members of the Tribunal, what we have here is a grave degree of incompatibility that can establish a common subject matter. Now, to be more precise, it is respondent's submission that arbitration under Article 8 of the BAT is directly incompatible with Article 18 of the Treaty on the Functioning of the European Union, prohibiting nationality-based discrimination. While at the same time we can detect...
Counsel, you said it needs to overlap substantially, and you've gone to one provision that particularly, in your view, overlaps. Could you point to me, where is free movement of people a part of the bid?
We would like to submit that the common subject matter of the BAT and EU law, the TFEU in the present case, does not have to be 100% coextensive, but the two treaties merely need to relate to the same subject matter.
And if they don't relate to the same subject matter in total, if they're not a full overlap, what test are you proposing? Any commonality?
We would like to submit first that in order to establish a common subject matter between two successive treaties, we need to see the cases where the application of the treaty can in fact be found. And here we have a BAT on the promotion and reciprocal protection of investment, providing for certain protection standards for the development of economic relations. This is actually a goal of the Treaty on the Functioning of the European Union as well, providing for the free flow of capital under Article 63 of the TFEU, as well as Article 49 of the TFEU on the freedom of establishment. So for this reason, we deem that there is actually an overlap that could qualify as commonality to their subject matter. Now, returning to our arguments...
Sorry, what is the test? How much commonality is needed? Any commonality between treaties is sufficient?
We would like to submit at this point that it is, if the treaties can be applied at the same time to the same events, then there is an overlap. For instance, if we have a dispute about the interpretation and application of law between the two contracting states to the BAT, this is something that falls to the exclusive competence of the European courts. So for this, in this instance, this actually could qualify as an overlap, which actually brings us to our argumentation on incompatibility. Now, arbitration...
Can I just ask, where do you get that from the plain wording of Article 59? Because you're reading Article 59.1a, or 59.1, the chapeau, as if it just refers to an overlap. But as my colleague is putting to you very fairly, it seems to be requiring something more than that. It's saying that the treaty relates to the same subject matter. So the treaty as a whole must relate to the same subject matter. Is that how you read it, or do you read it differently?
Indeed, this is a way that we can read this article. For instance, going back to the subject matter, the BAT provides for the development of economic relations between the two contracting states and foreign direct investment. This is also something that can be found as one of the main goals of the Treaty on the Functioning of the European Union. And for instance, we have common commercial policy, which is something that is common within the European Union's common internal market, regulating also relations to investment and foreign direct investment. So we deem that there can be a relation on that point. Now, returning to arbitration, members of the tribunal resorting to arbitration under the BAT is something that is not provided for every single investor acting within the European Union's common internal market. It is an additional dispute settlement mechanism solely offered to a limited group of investors with the sole criterion of their nationality. And as a result, the common rules of the European Union's common internal market, as well as the level playing field, can be distorted in a very severe way. And in addition to this, members of the tribunal, we would like to draw your attention on Article 10, paragraph 1 of the BAT, and please allow me to quote, that when a manner is governed simultaneously both by this agreement and by another international agreement to which both contracting parties are parties, nothing in this agreement shall prevent either contracting party or any of its investors who own investments in the territory of the other contracting party from taking advantage of whichever rules are more favorable to their case. Now, we would like to simply point out that this is a clause not commonly found in other intra-EU BATs. For instance, the BATs that have constituted legal instruments for intra-EU BAT cases, such as the Eureka, Eastern Sugar, Binder, Ostergedel, or Urim. And this is a distinctive factor of our case that can constitute a grave incompatibility. It essentially allows the contracting states to pick and choose and allows for the selective application of provisions, either under the BAT or EU law, by essentially putting in danger the unity of the European Union's legal order. And for this reason, we deem that it is incompatible. Now,
But how is that so different from the other more standard BIT provision where a party has an option to choose, for example, to go to the local courts or to an arbitral tribunal?
Madam President, we submit that in fact there is difference because this clause, Article 10, paragraph 1, allows actually the contracting states of the BAT to proceed to such a choice. And we would also like to point out that in the BAT there was the option to resort to the domestic courts of Barranquilla. However, the investor refrained from doing so. And by resorting to the domestic courts of Barranquilla, there would actually be no issue of interpretation or application of EU law because they are conferred jurisdiction to do so by the Court of Justice of the European Union. Now, only in the alternative, we submit that the BAT was terminated by mutual consent in 2008. And there are several instances...
Counsel, just before you leave I'm sorry.
No, I was just going to say, just before you move, I just want to check my co-arbitrators don't have questions.
Thank you, Madam President. The question was, under your first ground, you're saying it's automatically terminated. And the operation, it is not superseded in your view? It's no longer in existence?
We submit that the BAT is automatically terminated simply by virtue of Article 59 of the Vienna Convention because we acknowledge that the issue of supremacy within the European Union is a matter that mostly refers to the supremacy of community law over domestic law.
And
now,
if there is a provision of the BIT that is broader, not covered by the conflicting treaty, it is also terminated.
We would like to submit that, in fact, since they have a common subject matter and there is incompatibility, the BAT should be considered terminated. However, in the alternative that we are talking about specific provisions, then it is Article 30, paragraph 3 of the Vienna Convention that could very much apply, specifically referring to those provisions. Now, if I could have 1 minute to conclude my arguments. Thank you so much. Finally, we would like to submit that Cogitatia consented to the termination of the agreement since it was aware of our intentions since 2007, but also aware of the official position of the European Commission since 2006, which proposes the termination of such agreements. In corroboration, members of the tribunal, Cogitatia never objected to the termination from 2007 when the notification was sent until today. And we rely in good faith on the fact that they perceived the BAT terminated, especially as was the case with the termination of the BAT between Italy and Poland, where Italy sent a letter for the notification of Poland, and Poland, without explicitly agreeing, it now has removed the BAT from its official listing of valid and binding agreements in the Ministry of Foreign Affairs in their website. Now, Since my time has elapsed, we would like to conclude by stating that this tribunal lacks jurisdiction since the BAT was terminated in 2004 automatically, or in the alternative, in 2008 by mutual consent, clearly not covering our investor who initiated its investment in 2009. I thank you for your time.
Mr. Karen,
Yeah.
Just one question on your case on tacit consent. Can you point us to any authority that would support your case that an acknowledgement of a notice plus a limited period of time is sufficient to meet?
We would like to submit, yes, we would like to submit that in the case of AAPL versus Sri Lanka, the silence of the other contracting state was considered as qualifying as consent to the termination after the exchange of the notification.
What was the period of silence in the Sri Lanka case?
The period of silence was more, give or take, a rather small period of time. However, we do not submit that it is actually acquiescence that applies in our case, but merely implicit consent under Article 54 of the Vienna Convention.
Can I just clarify a factual point? You said Cogitatia has never objected to the termination of the bid until today.
Indeed.
Did you mean Cogitatia the state, or did you mean the investor?
We would like to refer to Cogitatia as the state, since it is a state matter. It has never replied explicitly rejecting the termination of the agreement, despite the fact that there have been numerous attempts to actually communicate on the matter with Cogitatia.
Okay, it was the until today bit that confused me. Well, could you refer me to where in the record they have now objected?
There is nowhere in the record the fact that they have objected, because Cogitatia has in fact never objected to the termination.
Perhaps I just misunderstood. When you said until today, I assumed there was an objection today, but you mean they haven't objected at all. As of today, they've never objected.
No, this was my
Right,
misphrasing.
that's what
I
thought.
mean,
Thank you.
from
No,
2007.
That's fine, thank you. Okay, please go ahead.
Good afternoon, Madam President, members of the tribunal. My name is Nadia Mulya, and together with my co-counsel, Mr. Joshua Gantan, we represent the claimant in this case, Visyuki LLC. Members of the tribunal, this is a case of a state which finds itself in a possible financial difficulty due to its own making, but instead of responding to the challenge in a fair and equitable manner, it reacted in a knee-jerk fashion by imposing a uniform, retroactive, and draconian change to its renewable energy scheme without taking into account the interest of the investors. It is in light of this that in the next 15 minutes, I will address today's procedural aspect, and that is whether or not the LCIA tribunal has the jurisdiction to hear the present case. Now, preliminarily, members of the tribunal, pursuant to the competence principle, and this is embodied under Article 23, Paragraph 1 of the LCIA arbitration rules, this tribunal may in fact determine on its own whether or not it has the jurisdiction to hear a case. With respect to the issue of jurisdiction, the respondent has alleged that the tribunal allegedly lacks jurisdiction in that the CBBIT has been terminated, and they relied on two primary grounds of termination. That is, first, termination due to, in fact, automatic termination due to the accession of both Cogitatia and the respondent state, and this is pursuant to Article 59 of the VCLT, or alternatively, termination by mutual consent pursuant to Article 54 of the VCLT. Now, preliminarily, while the respondent did not address this issue, the claimant sees the need to first look at the CBBIT and the termination ground that the CBBIT provides. And if I may refer tribunal to page 31 of the brief, specifically at Article 13, Paragraph 2. If I may read it for the tribunal's convenience, the provision clearly states that the CBBIT shall remain in force for a period of 10 years. Now, pursuant to Procedural Order Number 2, this tells us that the CBBIT is expected to remain in force until August 2012, and by virtue of the term thereafter in this case, any invocation of termination of the CBBIT may only be conducted after August 2012. And this precisely shows that Cogitatia and the respondent state have in fact consented to limit their inherent right to terminate their treaty only after August 2012. Thus, we submit that the respondent, the notification sent out by the respondent, and that was on 29 June 2007, in itself already ran counter to the provision under Article 13. Addressing the respondent's first submission, and that is pursuant to Article 59 of the VCLT, first the claimant would like to clarify the operation of Article 59 of the VCLT in that, in fact, Article 59 is only a termination ground. Thus, the accession of both Cogitatia and the respondent state to the EU did not automatically terminate the CBBIT, in that the respondent still has to comply with the procedural requirements under Article 65 to 67 of the VCLT. While the respondent in fact did not address the procedural matters, I would be happy to elaborate on this matter following my responses to their submission. With respect to Article 59, members of the tribunal, in fact, the respondent has rightfully noted that Article 59 of the VCLT requires the fulfillment of a two-pronged test, in that first, the CBBIT as the earlier law must relate to the same subject matter as the later treaty, the EU law, and in this case, the EU law being a collective assessment of numerous treaties, for instance, the TFEU. But only if the CBBIT and the EU law relate to the same subject matter would then arise the second assessment of either there had been an implicit intention to have EU law displace the CBBIT, or alternatively, that the two treaties are so far incompatible that they cannot be applied at the same time. With respect to the issue of subject matter, in fact, the respondent only primarily relied on the purpose of both the CBBIT and the EU law, and they alleged that the essence of both would be the free flow of capital. While claimant acknowledges that this is evidently one of the purposes of the CBBIT, in fact, the CBBIT covers more extensive protection and accords a more broader scope of protection than that of the TFE, than that of the EU law, in fact. Now, specifically, the respondent made reference to...
Sorry, counsel, can I just clarify that? So you said it has a broader scope. Do you mean a more stringent scope or actually broader range?
If I may clarify, Mr. Arbitrator, the CBBIT, by broad, I mean it provides more scope of protection than that of the TFEU. And this tells us that with respect to the scope of protection that exists in the CBBIT but does not exist in the EU law, that does not mean that the CBBIT should be displaced by the EU law. Now, with respect to the threshold of the issue of subject matter, the respondent has proposed a low threshold, and we assume that this would be in reference to the cases of Eureka and Eastern Sugar, in that it is sufficient for there to be more than a...
But I'm sorry, so you were addressing whether they address the same subject matter.
Yes,
Why
Mr.
would
Arbitrator.
the fact that one addressing the same subject matter, offering more protection, be somehow a different subject matter?
If I may clarify, in fact, the first assessment of subject matter is different when it comes to the subsequent protection of investments. So first, our claimant's stance is that, in fact, the CBBIT and the EU law do not relate to the same subject matter. But if the tribunal were to assume otherwise, we submit that the additional protection that the CBBIT confers should not be regarded as contradictory to the EU law, if that clarifies your concern.
Please proceed.
Now, with respect to the threshold of the subject matter, the respondent has proposed a lower threshold, and in the cases of Eureka and Eastern Sugar, we acknowledge that the threshold is that it is sufficient if the two treaties have more than a minor or incidental overlap. But even when the tribunals in Eureka and Eastern Sugar accepted such lower threshold, they nonetheless moved on to declare that the respective intra-EU BITs still remain valid. And in fact, factually, members of the tribunal, as of this date, there are still as many as over 190 existing intra-EU BITs, which again highlights that accession alone does not automatically terminate intra-EU BITs. Even going to the detailed arguments with respect to subject matter, for instance, the fair and equitable treatment under Article 2, Paragraph 2 of the CBBIT should not be regarded as available under the EU regime. Now, the closest provision that the respondent may rely upon would be Article 18 of the TFEU, which we acknowledge confers protection against non-discrimination. But in fact, with respect to the fair and equitable treatment under Article 2, Paragraph 2, it is not solely confined to the protection of against discrimination, but also entails other assessments such as legitimate expectations, arbitrariness, and due process. But even if this tribunal were to accept that the CBBIT and the EU law relate to the same subject matter, the claimant would argue that there is neither an implicit intention to have EU law displace the CBBIT, and nor are the two treaties so far incompatible that they cannot be applied at the same time. With respect to the intention, the respondent has raised the issue of the current ongoing infringement proceedings, and claimant duly notes the European Commission's negative stance against intra-EU BITs. Nonetheless, claimant submits that the negative stance of the EU should not negate the fact that ultimately it remains the discretion of the tribunal to determine whether or not the intra-EU BIT at hand has in fact been terminated. Because even in the cases of Ureco and Eastern Sugar, it is evident that the EC had already been negative towards intra-EU BITs at that point, but nonetheless, the tribunals ruled to conclude that the intra-EU BITs remain valid. Now, going to the issue of incompatibility, the respondent...
Counsel, so what is your response to respondent's motion that it would be appropriate for this tribunal to suspend its proceedings pending the resolution of that case?
We would respectfully disagree, Mr. Arbitrator, in that, in fact, with respect to the EC has remained silent throughout the proceeding of the present case. And even while we note, for instance, the case of Mikula versus Romania has been controversial in this aspect, in that the European Commission, for instance, criticized the ICSID's award for restitution for remedies that Romania had to give towards the claimants. Though in this case, procedural number 2 tells us that no claim of possible illegal state aid whatsoever has been lodged by the EC as regards the present case. Thus, the concern of the infringement proceedings would fortunately not apply in this present case. Going to the issue of...
Why does it fortunately not apply? Why does it fortunately not apply?
In that it remains, again, the discretion of the tribunal to freely determine the present case.
It's our discretion to decide whether to suspend or not.
That is also admittedly the discretion of the tribunal, though claimant would maintain that, in fact, the present case should be...
No, I'm sorry, counsel. So if we have discretion to suspend, can you elaborate on what should inform our discretion? What is the test for us to suspend? You conceded we have the discretion to suspend.
If I may clarify, in fact, all that claimant acknowledges is that the tribunal, pursuant to the competence principle, may decide whether or not it should continue the present case. However, it is our submission that the tribunal should precisely do so, because the CBBIT has not been terminated, and the issue of the EU should only be taken into account, but not wholly negate the tribunal's discretion. And in view of my time, members of the tribunal, if I may address the respondent's second ground of termination, and that is...
Just one moment. Okay.
And that is termination by virtue of mutual consent under Article 54 of the VCLT. Now, in fact, with respect to Article 54 of the VCLT, the commentary tells us that implicit consent, as the respondent has attempted to argue, is in fact insufficient in terms of establishing consent. Preliminarily, we acknowledge that Cogitaceous Act may not have been the most definitive in showing its objection to the CBBIT, and unfortunately, the claimant is of no position to rationalize, much less justify the actions of Cogitatia. Nonetheless, claimant would still maintain that solely by the silence on behalf of Cogitatia to deem that as one to constitute acquiescence, and I quote the ICJ at paragraph 304 of the Gulf of Maine case, would be overstepping the boundaries for acquiescence. Now, admittedly, rather unfortunately, the court in that case did not elaborate as to what would meet the threshold of acquiescence, but that precisely highlights the fact that in proving consent, it in fact requires a high threshold, in that it no longer it no longer constitutes a treaty termination issue, but rather state responsibility in terms of whether or not Cogitatia has waived its right. And again, this would be governed under the RCWA, thus entailing a different and higher threshold. With respect to our final point, and while the respondent did not address this, in terms of the termination of the CBBIT, in fact, the respondent did not fulfill the procedural obligations under Article 65 to 67 of the VCLT. Though we note that they have fulfilled the first obligation, and that is to provide a notification to invoke the termination, and yes, the respondent has provided such as of 29 June 2007.
Can I just interrupt you there? I mean, as I understand the case that's being made, it's one on tacit consent. And if the state has tacitly consented to the termination, then is there any need to go through these procedural provisions?
Yes, there would still be a need to go to the procedural aspect, Mr. Arbitrator, because even in terms of proving consent, again, it would require the act of the other party, in this case Cogitatia, and that would be an assessment part and parcel to the procedural requirement. And we note that Article 65, paragraph 2 of the VCLT entails a 3-month period in which Cogitatia should have responded to the termination.
But surely it's up to Cogitatia if it wants to insist on that 3-month period or not. And isn't it up to the parties simply to agree that they wish to terminate forthwith, just as it's up to them, so far as concerns your reliance on Article 13.2 of the BIT, to agree to terminate the BIT right away without waiting for expiry of the 10-year period? I just want to understand what your submission is in relation to application of these treaty provisions and the possible impact of consent of Cogitatia to a different regime.
The issue of consent, Mr. Arbitrator, is in fact separate from Article 13, paragraph 2 of the CBBIT, because we recognize that Article 54 entails 2 alternative elements, and that is under Article 54A, termination according to the treaty's terms, or alternatively, by virtue of mutual consent. Thus, this is our alternative argument in the event that the tribunal does not accept that Article 13 limits the exercise of termination. But claimant would argue that, in fact, there has not been any tacit consent to the termination of the CBBIT, because even looking at Article 65, paragraph 2 of the VCLT, if I may have additional time, given the time constraints. With respect to Article 65, paragraph 2 of the VCLT, the 3-month period should not be regarded as putting a bar to the period in which Cogitatia should have responded, but rather it is a minimum. And in this case, in fact, respondent could only have effected the termination if, and I quote Article 65, paragraph 2, if the party making the notification, in this case the respondent, wants to carry out with the termination, it must do so in the same manner provided under Article 65 of the VCLT. Thus, Article 65(2) of the VCLT requires a second diplomatic notification, which must be made in the first manner, in that it is written and signed by a head of state to actually effect the termination. Evidently, however, in this case, the respondent has yet to provide such diplomatic notification that would effect the termination. Thus, the claimant would conclude in that the CBBIT has in fact not been terminated, neither pursuant to the accession to the EU under Article 59 of the VCLT, nor by virtue of mutual consent under Article 54. And unless there are further concerns from the tribunal,
Nor by its terms, presumably.
if I may clarify.
Nor by its terms, presumably.
Not
It hasn't
by-
been terminated, you said, by accession or by mutual or tacit consent, but nor on its terms. But,
Yes, Madam President. And that would conclude my submission.
Thank you. Please proceed.
Members of the tribunal, we would like to point out 2 basic points in our rebuttal. First of all, we would like to submit that respondent was not obliged to terminate the agreement pursuant to Article 13 of the BAT, since it is a master of its treaty and it has the right to proceed to the early termination precisely under Article 54 of the Vienna Convention. And lastly, we would like to point out that, as opposing counsel for claimant very correctly stated, there needs to be an exchange of diplomatic written notifications, and this is precisely what happened in our case. And these can be found in Annexes 7.1 and 7.2 of the case. Finally, we would like to submit that indeed a 3-month period is not a bar to the consent given by the other state, but in our case, members of the tribunal, it has been long more than 3 months. It has been years, specifically from 2007 until 2015, still pending any objection. I thank you for your time.
So you say that the respondent state is the master of its treaty, but you're not suggesting it's entitled unilaterally to terminate the treaty, are you?
We are suggesting that since we are arguing for the early termination of the treaty, then the only way for this to happen could be through mutual consent. And we would like to firmly once again stress the point that implicit consent was given by the other state.
Thank you for clarifying.
If I understood your earlier submission, you were saying that your case on consent is supported by the fact that on several occasions your state wrote to Cogitatia and got no response. Can you just explain how that works in terms of a factor that we can take into account?
Certainly, I assume I have some time to answer to your questions.
Yes, please.
Thank you. Well, we should deem Cogitatia's conduct as far as the termination is concerned in an aggregate, Mr. Arbitrator. There is the fact that it was aware of Barankasian's intention, as well as the fact that they lacked to object. And in corroboration of this point, we would like to point out that there were numerous attempts, and through those numerous attempts, no objection was found. And we rely in good faith in the fact that since it is a matter also touched upon by the European Commission, who actually proposes the termination, then Cogitatia, if it actually wanted to object to the termination, it would have done so. And we also have examples within the European Union's common internal market, countries who terminated their intra-EU BATs, such as Italy and Ireland in 2012 and 2013 respectively, through mutual consent.
But doesn't the fact that there were numerous attempts at contact actually show that you had taken the view that there had been no termination by mutual consent, and therefore you were trying to push for a positive response so that you could proceed on the basis that the treaty had indeed been consented?
In fact, as far as the termination of international treaties is concerned, we would like to briefly state that it is a matter of legal certainty. And it was precisely because of this legal certainty that we proceeded numerous times to contact Cogitatia to verify their official stance. And we have also removed the BAT from our side, which was also an indication that we consider it terminated, still pending for any objections from Cogitatia.
Has Cogitatia removed it from its website?
We are not aware from the record. There is no information on that.
Please, Ms. Miller.
Members of the tribunal, just 2 points for rebuttal. Now, with respect to the duty to notify, the respondent has relied on the notification that it sent out, the subsequent statements by the Prime Minister, and the fact that the respondent continuously reached out, as well as the removal of intra-EU BITs. Now, first, with respect to the notification, in fact, as I have outlined under Article 65 of paragraph 2 of the VCLT, it remains a separate obligation to provide a second diplomatic notification. Thus, the first notification does not encompass the act of actually effecting the termination. But again, with respect to the statements made by the interchange that the respondent conducted towards the Cogitatian government, again, those, as the facts tells us, were conducted informally, thus falling short of the requirement to be written and signed by a head of state. And lastly, with respect to the removal of intra-EU BITs, in fact, as Madam President has touched on, the fact remains silent as to whether or not Cogitatia has done the same. And if we were to look at the tribunals in Eureka and Eastern Sugar at paragraphs 100 and 155 respectively, the tribunals concurred that intention to terminate intra-EU BITs would only be evident if both parties have removed their intra-EU BITs. It is clear that Cogitatia has not done so. And that would conclude my rebuttal.
Counsel, can I just ask? So I was impressed by your argument concerning 13.2. And I'm just wondering, in your view, could the two states have terminated this treaty?
If not by Article 13.2, Mr. Arbitrator, then yes, there would be an alternative of mutual termination. However, we submit that there has not been consent to terminate the treaty on the part of Cogitatia.
I understand that, but if we were to find that, they could terminate the rights of any expectations of any investors, in your view?
Only by virtue of mutual consent, Mr. Arbitrator.
Thank you.
Thank you.
Thank you. I'm just mindful of time. If the arbitrator's questions, I think it's better to have the questions, so we'll try and keep on to time, even if that means you don't deal with all of your submissions. So 17 minutes. Oh, you have a further response? No.
No.
No. 17 minutes, please, from the claimants on merits. Mr. Gunter, please. Gunter.
Good evening, Madam President, Mr. Arbitrators. My name is Joshua Gantan, and I'll be addressing the issue of merits as well as remedies on behalf of the claimant on two separate submissions. In my first submission, I'll be addressing the issue of merits for 17 minutes. This case is about Vasuki LLC, an energy company that has contributed to the development of the photovoltaic sector in Barranquilla by investing in reliance of Barranquilla's feed-in tariff scheme. However, once Vasuki has parked its capital by constructing the solar projects in Barranquilla, it found that the respondent withdrew the incentive scheme, therefore resulting in the claimant's destroyed profitability of its business. Thus, here the claimant would like to defend two basic contentions. First, the respondent has violated the fair and equitable treatment standard as found in Article 2, Paragraph 2 of the CBBIT. And then secondly, in fact, there are no defenses available for the respondent to justify its actions. We turn now to the first part of the submission under merits then, that the respondent has violated the FET standard under the CBBIT. Now, the FET standard has been long understood by a long array of past tribunal to include a number of protections. First, investors' legitimate expectation. Second, protection against host states' arbitrary conduct. Third, protection against host states' failure to court due process of law. And fourth, protection against host states' discrimination. Now, we submit that the first three of these four protections has in fact been violated by the respondent. We turn to the issue of legitimate expectation. And here the claimant submit that its legitimate expectation for regulatory stability was violated when the respondent amended the LRE on 5th January 2013. Members of the tribunal, admittedly, there is no stabilization clause between the claimant and the respondent. However, past tribunal have ruled that even in the absence of such a clause, legitimate expectation for regulatory stability could still be found. And the case of Mikula versus Romania is instructive in this regard, where similarly there, the government of Romania attracted investors in certain disadvantaged region by putting in place a number of incentive schemes, such as tax incentive. And there the tribunal looked at two sources of assurance for stability. First, the law, the measure, and second, the subsequent conduct of the host state in affirming the assurance by law. And in our case here, the assurance by law is to be found in the LRE Article 4, which, if I may invite this tribunal to turn to page 32 of the record, provides that the feed-in tariff, once announced by the Barranquilla Energy Authority, will remain in place for a period of 12 years. We submit that that is an unqualified assurance for stability. Now, the second source of assurance is to be found in the approval of the Barranquilla Energy Authority for the license of Beta, as well as the 12 projects. In the word of the tribunal in Mikula, such approval of license crystallized the assurance for stability. Now, it is important to take note, particularly the date where the 12 projects licenses were approved, on 1st July 2012. This approval of license was made despite a series of events that would have called for the abandonment of the scheme. It was made even after Barranquillan public officials recognized that the scheme might be unsustainable, even after there were nationwide teacher strikes protesting against the scheme. And although the government of Barranquilla could have stopped issuing the license or issued the license with certain reservation that it might be changed in the future, it did not. Rather, it continued to approve not only claimants' 12 licenses, but also 6,000 other investors' licenses on 1st July 2012. We find clearly, therefore, an assurance for regulatory stability. We turn now to whether...
I'm sorry, can I just ask a question? Does that not cut both ways, though? Because equally, the investor was on notice at the time it applied for the 12 licenses. It was on notice that the officials were concerned about the effect of this tariff and the 12-year term of the tariff. And they were concerned that the whole renewable energy support scheme on that basis was unsustainable.
Yes, Madam Arbitrator, indeed there is a legitimate concern. And what is of particular importance here would be the...
What do you mean that's a legitimate concern as you answer the question?
In fact, the claimant itself, as a business, as an investor, would have considered the situation at the time. And at that material time, in the intervening period, where the Barranquillan public officials were concerned with the sustainability of the scheme and the approval of the license, the claimant were looking very closely on whether or not the respondent would have maintained the stability of the scheme as provided under law. And this assurance was found when the respondent approved the licenses unreservedly on 1st July 2012.
Can I ask you, often the cases talk about investment-backed expectations, and as I understand it, there is a gap in time between your investment or certain aspects of the investment and the 1st July 2012 approval of the licenses. So can you explain to us how your case by reference to the licenses helps with respect to investments made prior to that date?
Yes.
And indeed, with respect to investments made after that date?
Yes, Mr. Arbitrator. Admittedly, with respect to the approval on 12th July 2012, it would be relevant only to the 12 projects which received the specific assurance. As regards beta, however, it still received the general assurance under law. And of course, admittedly, to answer the question, Project Alpha did not rely on the LRE scheme as it was constructed prior to the enactment of the LRE on 1st July 2010. Now, having established that there was such an assurance, we then assess whether this was relied upon by the claimant. And here we submit evidently so, because the claimant only began the construction of beta and the 12 projects after they received the license from the BEA. And it is a reliance that is reasonable because the respondent itself maintained the stability despite trying circumstances. Thus, we submit that the claimant's legitimate expectation for regulatory stability was clearly violated when the respondent changed the LRE scheme, enabling them, instead of respecting the 12-year stability, to now being able to change it on an annual basis by virtue of the amendment. We turn now to the second ground for the violation of the FET standard, namely the respondent's arbitrary action in denying the license for Alpha. Now, members of the tribunal, the test for a host state's arbitrary conduct were to be found in the case of Metalclad, where the tribunal ruled that a host state would act arbitrarily when they disregard the rule of law and when they acted inconsistently with the law. Now, in our case here, the relevant law would be the LRE Article 5, as well as the LRE Regulation Article 3, which, if I may read to you on page 32 and page 34, respectively, the LRE Article 5 provides that existing capacity of electricity production from renewable energy sources may develop upon obtaining a license from the BEA. As regards Regulation Article 3, it provides that a renewable energy provider, upon obtaining a license for the development of existing photovoltaic capacity, is entitled to the feed-in tariff. Now, a reading of those two articles taken together would provide the tribunal with the understanding that under law, it is possible for an existing operation to be granted a license. However, when we turn to paragraph 22 of the facts, it provides that on 1st August 2010, the BEA denied Alpha's application of license solely on the ground that it was an existing operation. It went further by saying that in fact the feed-in tariff scheme would only be available to new projects. We submit therefore that the BEA has acted against its own law and thereby going against the rule of law and otherwise an act known as ultra vires. However, the arbitrariness of the respondent did not stop there. The respondent also acted arbitrarily in implementing the LRE amendment. Although the very rationale of the LRE amendment was to be fair, taking into account, and I quote here the LRE amendment, the cost of the best available technology as found on page 35 of the record, the reduction of the feed-in tariff from 0.44 to 0.15, 65% reduction, was done indiscriminately to old projects that in fact could not benefit from new technology as Procedural Order Number 2 provides, that they would be incompatible. Thus, old projects, such as Beta, that did not benefit from the new technology which have brought a lower cost, suffered equally with new projects, such as the 12 projects, which did benefit from the feed-in tariff from the new technology. Thus, in that regard, the very implementation of the LRE was against its rationale to be fair in terms of the cost of feed-in tariff accorded to operations.
So you think the state should subsidize the claimant for failing to have the most advanced technology installed in its plants?
Not at all, Madam Arbitrator or Madam President, but what the claimant submitting here simply is that the respondent has in fact failed to act consistently with the very rationale of their own amendment. Now, as regards Beta, the damages was already done in its denial of the 0.44 tariff rate on 5th January 2013.
Counsel?
Can I ask you,
Please go ahead.
can I ask you a question about your test for arbitrariness?
Yes.
As I understood it, you were saying that it was sufficient that the state act inconsistently with its own laws for there to be arbitrariness. So, on that understanding, isn't that just a means of elevating from the domestic level, any breach of domestic law, to a breach of international law? And my question to you is does arbitrariness not require something more than a mere breach of domestic law to show arbitrariness? Supposing the state has a very good reason for changing its domestic law or for acting inconsistently with it.
Yes, Mr. Arbitrator is right in that sense, in that perhaps there is a more intricate detail to the test of arbitrariness. And here, if I may supply this tribunal with more detail on it, is that there is an element of discretion when it comes to a violation of the arbitrariness standard here. The tribunal in Metalclad ruled that arbitrariness can be found when the state acted in its discretion and did not also provide a reasonable explanation for it. And here I would like to draw the tribunal's attention to the fact that in Procedural Order Number 2, the BEA refused to explain the criteria applied for the approval of license, citing confidentiality reason. And thus we submit that adds a degree of arbitrariness in its denial of license, Mr. Arbitrator.
Are there any other authorities you can point us to on arbitrariness apart from Metalclad, which of course is a reasonably old authority now?
Yes, Mr. Arbitrator, we would like to highlight the case of, if I may have a moment, we would like to refer to the case of TechMed 2, where the landfill operator projects did not receive a proper treatment when the license was denied by the government of Mexico. It was also arbitrary because it was based on the discretion that was not further elaborated thereupon. Now, having
Counsel, before you leave that, I have a similar concern. So on these two limbs, you said first they acted against their own law, and then you said they were inconsistent with the rationale behind their law.
Yes.
Who is this tribunal to be questioning their decisions, and how do we go about actually reviewing a domestic decision? You said the test you offered was reasonable, so we offer no deference to their decisions.
Mr. Arbitrator, in fact, here the relevant point would be to assess whether the law itself, which provision could be found on page 35, that is the LRA amendment, was implemented in a manner that is consistent with its own wording. That is to take into account the cost of best available technology. And a finding that the implementation goes against it would suffice to derive the conclusion that there was arbitrariness, as the implementation was inconsistent with the law itself.
So it's just our decision. We review their decision. That's we apply the law, and if they got it wrong, that's the key.
In the tribunals, of course, in the tribunals' attempt to find such a violation, there should be due regard paid on the law itself. And here, certain respect was paid on the law itself, which the very rationale was taken into account here.
Thank you.
We turn now to the second part.
So, Mr. Ganton, just on timing, we've got 1 minute left, so could you just conclude?
Sure.
And then we'll go to respond.
Okay, very briefly now on the issue of defenses, we submit that the two possible grounds of defenses that the respondent might resort to, the treaty-based defense under Article 11, is not available because the ESI clause is strictly limited to maintenance of international peace or security, which tribunal and continental ruled is to be strictly applicable only in a situation of military conflict or external threat, which is practically absent here. The second possible ground of defense would be the the defense of necessity under customary international law. But we submit here that there exists such a high threshold there, and the situation in Barranquilla is simply far below the threshold provided by past tribunals. We therefore conclude under merits in saying that there are breaches to be found under the FET standard, and this cannot be justified under any defenses.
Many thanks, Mr.
Thank you very
Ganton.
much.
And respondent, Ms. Aslandi, is it?
Yes.
Excuse me?
Ms. Aslandi, you're going next?
Yes.
17 minutes, please.
Yes.
Proceed.
Good afternoon, Madam President, members of the Tribunal, learned counsel for claimant. My name is Despina Arslanidi, and for the next few minutes, I will be representing the merit stage of the present dispute. In particular, members of the Tribunal, first, I will address the issue of the non-violation of the fair and equitable treatment standard under Article 2, Paragraph 2 of the BAT. In particular, it is our submission that parties have gathered before you today, members of the Tribunal, motivated by totally different incentives. On the one hand, there is an EU member state which is striving to develop its renewable energy sector in a sustainable way in order to be able to provide the vital public service of electricity within its territory and its own people. On the other hand, there is an EU investor, Vasiuki, who, despite keeping its licenses intact, is requesting for a frozen legal framework, ignoring the overall worries for energy security within Europe in general and Barranquilla in particular. Members of the Tribunal, we would like to address respondents' points in the same order. First, we will prove that claimant's points. First, we will prove that respondent has respected claimant's legitimate expectations. Second, we will prove that the denial of a license for the Alpha project was by no means arbitrary. And finally, that the imposition of the lower feed-in tariff also for the Beta project was by no means discriminatory. Coming to our first point, members of the Tribunal, we would like to stress out that claimant's allegations are fundamentally flawed from the very beginning. Claimant does not have expectations for a fixed feed-in tariff for 12 consecutive years. Claimant seems to base its expectations and its whole argumentation in its very persistence on Article 4 of the Law on Renewable Energy. However, this persistence on this article is fundamentally misplaced, members of the tribunal, because it fails to take into consideration the rest of the law's provisions, and in particular Article 1 of the LRE, which refers to the purpose of the law. At this point, I would like to address the tribunal to page 34 of the record, and in particular Article 1 of the 32, of the record, and in particular Article 1 of the LRE, which sets the purpose of the law, which is, and I quote, to ensure sustainable development of the use of the renewable energy sources. As a result, members of the tribunal, any alleged expectation on behalf of claimant is circumscribed by the very provisions of the law. Hence, Article 4 of the LRE should not be considered in isolation, but always in correlation with the purpose of the law, the sustainability of the photovoltaic sector. This especially holds true for claimant, who is an EU investor investing in an EU member state. Members of the tribunal, claimant referred to the fact that it could not possibly know, and that the respondent has not made any reservation regarding the amendment of the legislation. However, it is an uncontested fact that after the strikes of 2012, the government of Barranquilla announced publicly that it would review its legislation. In addition, being an EU investor...
Excuse me, Counsel, can I go back to the law for a moment? So, you were stating we need to read Article 4 in light of the purpose of the statute.
Indeed.
Are you conceding that Article 4 itself, in its own terms, creates such an expectation?
We believe that since the license is offered to claimant, allowed it to operate under the law on renewable energy as a whole, it is Article 4 together with Article 1 that creates the expectation to claimant.
Yeah, I understand that argument. The question I have is whether in isolation, before we proceed to reading it in combination with Article 1, your view is it does say that there is an expectation for 12 years.
In order to clarify our position, it is our position that claimant's expectation is the expectation of a feed-in tariff scheme that would preserve the sustainability of the photovoltaic sector. Article 4 in corroboration with Article 1.
Thank you, Counsel.
Thank you.
Can I ask if there are any other parts of the law that you rely on? In particular, are there any other parts of Article 1, or do you rely on any of the other provisions?
Certainly. It is also the fact that in the end of paragraph 1 of Article 1, we can see that the state also must serve the objective and the requirement of security and reliability of energy supply, and also take into account the principles of consumer protection and legitimate interests. Which actually brings me, members of the tribunal, to my next argument, that respondent has enacted its undeniable right to regulate towards a legitimate regulatory purpose. And especially in the absence of a stabilization clause, it has been several tribunals, such as the AES, the Impregilo, and Park Hearings tribunals, that have affirmed that any reasonable businessman should expect that the law is about to evolve. And in our case, respondent has enacted its right to regulate towards a legitimate regulatory purpose, the provision of electricity within the state of Barranquilla, and the protection of energy security issues. In fact, what we did was apply the same test that was applied in several cases, such as Saluca, Total, and AWG cases, which state that a weighing needs to be made between the investor's interests and the state legitimate regulatory interests. And this is exactly what respondent did, members of the tribunal, in our case. After the technological breakthrough of 2011, respondent had seen an unmanageable number of investors coming in the country and requesting to be connected to the national electricity grid. As a result, this put a threat to the very operation of the national electricity grid, since we know from the uncontested facts that it would be physically impossible to connect these investors to the grid. What is more, members of the tribunal, a 15% proportion of the state revenues would have to be reallocated to the photovoltaic sector in order to fund these investors and for the state to be able to comply with its obligations. What we did, members of the tribunal, was both respect the investor's interests and the state's interests. Regarding the investor's interests, it is a fact that the investor has managed to keep its licenses intact, and therefore it is evident that we have also respected an at least 8% rate of profitability that was maintained for the investor, the same rate of profitability that the investor was entitled to under the previous feed-in tariff regime. Members of the tribunal, had the amendment not happened, the investor would for sure end up with no licenses at all, as the practice of other member states also has shown. For instance, Spain and Greece, that have adopted more gradual approaches in regarding to such problems in the beginning, finally they ended up abolishing the feed-in tariff scheme in its totality. Regarding claimant's argument on arbitrariness, it is our submission, answering also to Mr. Arbitrator's question, that an arbitrary act, as was defined by the Siemens Tribunal, needs to be an unrestrained or despotic action. And in our case, members of the tribunal, the license that was denied for the Alpha project was an action on behalf of the state that was done in perfect accordance with the legislation. We would like to refer the tribunal to page 32 of the record once again to see Article 5 of the LRE, which specifically state that existing capacity is entitled to licenses as long as it may be developed. Members of the tribunal, the Alpha project is a project operating with high deficiencies from the moment of its very installation, a project that never managed to reach its 21% capacity, but only has managed to reach a 12.1% capacity, members of the tribunal. The purpose of the LRE is to provide for a sustainable photovoltaic sector, not to provide hope for already failed projects. And therefore, members of the tribunal, the mere expectation of ASIUKI's managers that the Alpha project would be entitled to license, and this is exactly the reason because why they kept it into life, does not make it eligible for license. Finally, members of the tribunal, regarding the argument about discrimination towards the Beta project, it is our submission that what respondent did was treat equally all the projects falling under the law on renewable energy. As all the projects under the previous regime deserved a 0.44 euros per kilowatt per hour feed-in tariff, this feed-in tariff was subsequently reduced to 0.15 euros per kilowatt per hour feed-in tariff for the Beta project as well. And in fact, we should regard ASIUKI as an investor, as a company, as a whole. ASIUKI was operating 14 projects, one of which, the Alpha project, was not entitled to a license, and the 12 of which were operating with a new technology, which means with reduced costs, members of the tribunal. It is therefore evident that for the company as a whole, the 8% rate of profitability at least was still preserved. Members of the tribunal, returning to the defense stage of the present dispute, it is our submission that in the unlikely event that this tribunal finds that respondent has possibly violated Article 2, Paragraph 2 of the Bilateral Investment Treaty, it will still be exempt from responsibility. The reason for this, members of the tribunal, is that the actions that respondent has undertaken were in order to safeguard energy security matters, and therefore falls under the scope of Article 11 of the Bilateral Investment Treaty, and in any event, under the state of necessity under Article 25 of the ILC articles, which reflects custom. Now, allow us, before proceeding to the legal sources, to describe first some basic factual points regarding energy security, which is the crucial parameter in the present dispute.
Counsel, could you describe or give an example of a situation that would exist, you would need these defenses if this tribunal were to accept the right to regulate that you argued before us?
If I understand your question correctly, you mean if you accept, you said, the right to regulate?
You defended your actions as not being a breach because it is within the right of your state to regulate these activities. And if this tribunal recognizes that right, when would it be that you would ever require recourse to these defenses?
Indeed, we would not require recourse to these defenses. It is only in the event that the tribunal does not see that the right that respondent has enacted legitimately is right to regulate, that we resort to Article 11 of the Bilateral Investment Treaty, which exempts the wrongfulness of respondents' actions, and again in the alternative to Article 25, which exempts respondent from responsibility. Members of
the Council, if the parties intended such a broad right to regulate, why did they include Article 11?
It is precisely because Article 11 refers to specific issues that are not exactly the same with the ones that we presented in regarding the violation of Article 2, Paragraph 2 of the Bilateral Investment Treaty. Article 11 refers to the right of the states to take measures in order to fulfill their obligations with respect to international peace or security. And members of the tribunal, it is our submission that it was also international security that respondent was protecting in the present case. In fact, international security has been determined by Professors Berg-White and von Staden as not restricted to global issues solely, but also including matters regulated by regional organizations. And such regional organization in our case is the European Union. Members of the tribunal, the energy security issues that we will shortly describe that respondent was trying to protect are also issues covered by the European Union directives and are also issues that have been verified by the European Commission as problems that the European Union faces also itself and need to be tackled by the member states. Issues towards which all member states need to take action, given the interdependence between the member states in matters relating to energy.
Can you point us to a specific obligation that you have in mind in relation to Article 11? Did any concerns taking measures to fulfill obligations with respect to the maintenance of international peace and security?
You're referring to Article 11 of the Bilateral Investment Treaty?
Yes.
Yes. It is our obligation under European Union legislation, and in particular the directives on renewable energy states specifically, the directive on renewable energy states specifically in its preamble that the purpose of the directive is to ensure the sustainable development of the photovoltaic sector, and also the directive on electricity states that it is also a purpose of the EU member states to promote and tackle the problem of energy poverty, which is a hot issue within the European Union, since 10.8% of the population is suffering from this problem. And it is precisely these two aspects of energy security that respondent was trying to protect. Regarding the element of energy, of the sustainability of the photovoltaic sector, when the measures challenged were taken, it is our submission that respondent was facing a solar bubble already since 2012. The mere receipt of 7,000 applications that were to be connected to the national electricity grid was in fact something that the grid could not sustain. The national electricity grid, had not these measures been taken, would eventually collapse, and Barranquilla would be unable to provide the fundamental public good of electricity within the country and its own citizens. In addition, members of the tribunal, unable to resort to any further borrowing due to the EU-mandated borrowing limits, and given that other sectors of the state were subfunded, such as the educational sector, the one that would eventually bear the burden of the 15% reallocation of the state revenues that needed to happen would be the consumer, by either an augmentation in its taxation or a relevant augmentation in its electricity bill. But this would only deteriorate the problem, since it would create the earlier described problem of energy security within the territory of Barranquilla. Therefore, members of the tribunal, it is our submission that for these reasons, it is evident that Barranquilla was acting in the protection not only of its national energy security issues, but also towards the protection of the European Union energy security issues as well. In addition, we deem that the same situation can apply for Article 25 of the ILC articles only in the alternative and in the case that the tribunal does not see that energy security issues are covered under Article 11 of the Bilateral Investment Treaty. If I'm not of any further assistance, this concludes my arguments.
Thank you.
Thank you.
Claimant.
Under rebuttal, the claimant would just like to raise two brief points. Firstly, pertaining to the denial of license to Alpha, and secondly, as regards the defense under Article 11. Now, pertaining to the denial of license to Alpha, although the respondent mentioned that the license was denied because Alpha was defective and because it has already at the 30 kilowatt capacity, that was not the reason given out by the BEA when it denied the license to Alpha on 1st August 2010. But rather on paragraph 22 of the facts, you will find there that the BA denied the license solely on the ground that the Alpha project was an existing operation and further stated that the scheme will only be available for new projects. The second point of rebuttal is pertaining to the issue of defense under Article 11. Now, even if granting that the scope would cover the situation in Berengkaja, there exists still a test for what sort of measure can be taken under Article 11. And here, the Tribunal of LGNE and Continental referred to the WTO jurisdiction of tests that involves a weighing and balancing of investors' right as well as public interest. The measure introduced should be one that is least restrictive. However, there exists an alternative that is least restrictive to investors' right while also helpful in terms of helping the respondent in meeting its EU renewable energy obligation. And that would be for the respondent to spare existing investors, spare existing license holders from the tariff cut, but to impose the tariff cut for new license holders. In that way, it would spare the respondent from the financial difficulties that might arise while also continuing to help them meet the EU tariff by maintaining the incentive scheme.
Can I ask you just a question going on from that last submission? Is the wording in LGAA, is that equivalent to the wording of Article 11? I don't mean by reference to obligations with respect to the maintenance of international peace or security, which is possibly a rather limited pool. But in LGAA, is there any other difference in the wording?
There are two striking differences between the ASI clause, which we find at the CBBIT, and the US-Argentinian CBBIT assessed by the LGNE Tribunal. The first will be the absence of the wording maintenance of public order. The second would be the absence of the wording of the host state's own essential security interests. And it is precisely the absence of these two phrases which led us to the submission that the scope of this clause is strictly limited to the maintenance of international peace or security, applicable only to a situation of military conflict as under the UN obligation.
On the natural reading of Article 11,
yes.
Isn't it open to the state to do whatever it wishes, so far as concerns it being a bona fide measure to fulfill obligations, as opposed to from taking measures necessary to fulfill obligations? In the absence of any wording such as necessary, would the LGAA type analysis apply here?
Well, we submit no, Mr. Arbitrator, because such an interpretation as proposed would be in a very difficult tension with what is already customary, in that to the extent the ESI clause is to provide such a margin of appreciation, typically as in the LGNA Continental case, there you will find the phrase its own essential security interest. But there is no such wording of its own in the ESI clause. And the best explanation to this we submit would be to the fact that both contracting parties at the first signing of the BIT have already limited the scope of the very ESI clause itself. Thank you.
Members of the Tribunal, in our rebuttal, we will address both respondents' points in the same order. Regarding claimant's first point, members of the Tribunal, in fact, the Alpha project already had a license under the previous regime, a license that gave the right that gave it to it the right of a 0.1989 euros per kilowatt per hour feed-in tariff. Therefore, we cannot see how respondent could be be perceived as acting in an arbitrary way towards the Alpha project. It was exactly because in the legislation itself, according to the legislation itself, the Alpha project was not entitled to a license, that the Alpha project was denied a license. And in fact, the BEA's justification given to the investor was that existing projects do not have the certain right, always under the premises of the LRE, which was public. Article 5's prerequisites were known to the investor, and therefore the investors knew exactly why the Alpha project was denied the license. Now, regarding the two cases to which claimant referred to, the LGND and the Continental cases, we would like to state that this is a totally invalid comparison. First of all, the LGND case examined Article 11 and the relevant Article 11, the MPM clause of the Bilateral Investment Treaty, and Article 25 of the Customary International Law separately. And therefore, the requirement of the alternative measures was given by the LGND case only regarding customary international law, not in relation to Article 11. In addition, the Continental case, which did this conflation, bringing the requirement of the only way back to the MPM clause, was heavily criticized for doing so first, and second, it did so exactly because the word necessary was included in the MPM clause of the US-Argentina Bilateral Investment Treaty, which is definitely not the case here. Thank you.
Could we move then, please, to claimant on remedies? 4 minutes, please.
The claimant submits that it is entitled to first receive an order that the tribunal instruct the respondent to continue paying the claimant for the 0.44 feed-in tariff, the pre-amended feed-in tariff, and the alternative to that, to compensate the claimant for all the damages that it suffered. We first now turn to the issue of specific performance. The claimants submit that by virtue of entering into the CBBIT, and particularly here we would like to highlight Article 8, Paragraph 2D of the CBBIT, the respondent cannot raise any objection pertaining to its sovereignty being infringed by undertaking specific performance. The CBBIT Article 8, Paragraph 2D provides that should any dispute be lodged into the LCIA tribunal, both parties would be subject to the LCIA arbitration rules. And the LCIA Arbitration Rules 2014, Article 22.1.7 provides that the tribunal has the power to order for specific performance for legal compliance, and here we refer to the legal obligation found under the license that the claimant has.
Can I just ask you a question about Article 22.1? I notice you stopped citing the article at one point, but it refers expressly to specific performance of any agreement. What would be the agreement here within the language of Article 22.1?
Here we submit the agreement would be in the form of the license that the respondent itself has provided for beta on 1st August 2010 and for the 12 projects on 1st July 2012. And even if this tribunal were to find that the specialist basis under the CBBIT might be weak, customary international law would provide the basis for this tribunal to order specific performance under Article 35 of the RCWA. And in fact, past tribunals have noted also that there is an increasing trend in giving order for specific performance. We refer here to the tribunal in Goods versus Burundi and the tribunal in NICOM versus Latvia. And here we would like to suggest this tribunal to fashion its award in a manner that is similar to the tribunal in NICOM and Latvia, where the claimant is to be ordered to perform specific performance, and in the event that they fail to do so within 6 months period, to then be under the obligation to compensate the claimant. This brings us then to the issue of compensation. And under this issue, very briefly, the claimant would like to submit that the basis of damages here are two types. First, historical losses, which come about from Alpha's denial of license since 2010, which brought about reduced income, and also from Beta's reduced income due to the amended tariff since 2013. As regards the future losses, it come about from the fact that Beta, the 12 projects and future developments would have been entitled to a higher income up to 2023, but for the amendment. And the most contentious issue, it seems, under the issue of damages would be what would be the basis for this tribunal to award lost future income. And here we submit that there are three very strong bases for this tribunal to award such an award. First, there exists already a license which constitutes a legally protected source of income. The tribunal in Guaracaki versus Bolivia ruled that a license which provides such a legally protected income would be a strong basis for an award of future income. Second, there already exists an excellent track record of profitability on Project Beta since 2011. The tribunal in Mikil ruled that an operator's excellent track record for its one particular project can be used as a basis for the prediction of the success of its other projects. And again, the last point of basis here would be the fact that after the lesson learned from Alpha, the facts tell us that the claimant gained tremendous know-how in the solar industry. This again provides as a basis for the future project's profitability. In quantifying for the damages, we submit the DCF method would be the most suitable with the WACC discount rate, and the amount that is due to the claimant for the losses suffered by Alpha, Beta, the 12 projects, and the future developments come up to €2,437,217. The claimant therefore rests its submission.
Thank you very much. Respondent, 8 minutes, please.
Madam President, members of the Tribunal, learned counsel for claimant, we would like to once again submit that we have accorded the investor fair and equitable treatment, and in any case, the wrongfulness of our action may be exempted under either the BAT or customary international law. Now, as far as claimants' requests are concerned, we've heard today that the investor requests from the state to continue to pay the investor the pre-2013 feed-in tariff in the form of a specific performance, and only the alternative compensation of approximately €2.1 million as it is indicated in the record. Now, we submit at this point, members of the Tribunal, that restitution or specific performance in the form requested by the investor should not be deemed as the appropriate remedy in the present dispute, and compensation should be far less than the amount that the investor is asking. Now, it has been highlighted, members of the Tribunal, especially by Professor Douglas, that if a remedy, that actually restitution, even in the form of specific performance, if not included in the BAT, it would directly interfere with the state sovereignty. Now, if we take a look in our BAT, there is absolutely no reference to any remedy as far as the violation of fair and equitable treatment is concerned. And for this reason, we would also like to resort to Article 35 ILC. Now, according to Article 35 ILC, if the measure proposed as far as restitution is concerned is something disproportionate when compared to compensation, it should not be awarded. And in our case, what the investor is essentially asking, members of the Tribunal, is to oblige a state to continue to provide a feed-in tariff that was deemed that as something that was not suitable anymore for the sector, and risk its own relations with the European Union by actually creating discrimination based on nationality contrary to Article 18 of the TFEU. Because by providing to one single investor the pre-2013 feed-in tariff, there would be distortion of the photovoltaic market of Barranquilla solely on the grounds that the investor benefits from the Barranquilla Cogitatia BAT on the grounds on its nationality. Now, we submit, members of the Tribunal, that restitution or specific performance as requested by the investor is not the appropriate remedy in the present dispute, and only compensation should be considered, that in an amount of far less than €2.1 million. Now, members of the Tribunal, before proceeding any further, we would like to stress the fact that the future expansions of claimants' investment should not be considered or taken into consideration in the compensable amount. And this should be disregarded as something completely speculative, a hope and a mere anticipation that the investor has, since there is absolutely no documentation that those projects are happening, that those projects are established, let alone the fact that they will be getting a license or perform at a 21% capacity as Project Beta. And to this point, we would like to submit that the investor is essentially cherry-picking between the most successful of its projects, since it is given to us in the record that Project Alpha was heavily deficient, operating at merely 12.1% rather than the initially projected 21%. And for this reason...
Could I just interrupt? I just want to go back a little to your submission on specific performance, just so I can understand it. Is it your position that we're not in a position to order specific performance if we consider that's the appropriate remedy because the states haven't agreed to it?
Well, if we read the BAT, indeed, the states have not considered specific performance as an available form of remedy. But if we resort to the LCIA rules, then even in this case, specific performance is referred in a wholly different context. For instance, in the possibility of a contract or an agreement. Now, a license, it is our submission that does not qualify as a contract or an agreement. So there we have a difference that should not be disregarded. Now, if we could go back to the quantification of damages, respondent would like to stress the fact that indeed the DCF method is not contested on behalf of respondent, that it is the appropriate remedy, the appropriate method to actually calculate damages. However, there is one major and key difference between the quantification of damages on behalf of claimant and on behalf of respondent. We submit that as it is evident by Annex 4, page 5 of the record, claimant's expert actually calculates the future cash flows of the company after debt has been subtracted. Now, in order to clarify our point, in the functioning of the DCF, the discount rate is something very crucial and a key component. And the discount rate essentially mirrors the risks undertaken by the investors. If we apply the weighted average cost of capital as proposed by claimant, then we would be taking into consideration both cost of debt and cost of equity. However, it is clear by Professor Kovitz's calculations that it is not both cost of debt and cost of equity that are taken into consideration, because as it is illustrated from Annex 4, page 2 of the record, debt has already been subtracted. And members of the tribunal, it is not only that, but also the fact that the investor could have very easily proceeded to debt refinancing. And this is also a point that we would like to link both to the interest rate and to the discount rate and to the mitigation that the investor had the obligation to do. Now, we are informed from the record, and in particular, Procedural Order 2, Procedural Order 3, Paragraph 2, that the interest rates on commercial bank loans on Barranquilla are actually 0.4%, which is virtually nearly to zero. Now, we are also informed from the record that our investor had borrowed money from cogitation banks at an interest rate of 5%. And as a result, it could have very easily mitigated its losses by proceeding to debt refinancing, repaying its bank loans from cogitation banks with an interest rate of 5%, and actually preserve the minimum risk of 0.4% as a discount rate. Now, in addition, we would also like to point out that the land plots purchased by claimant are now worth 10% more than their original price. And any prudent investor, members of the tribunal, would in fact sell those land plots and gain 10% profit and not only depreciate for its expenses. Now, to briefly conclude, we would like to once again submit that specific performance is absolutely not the appropriate remedy to be awarded in the present dispute, and in the unlikely event that we are found liable by this tribunal, compensation is due in an amount far less than 2.1 million euros, excluding Project Alpha, as well as claimants' future installations, since they constitute nothing more than clear speculation. This rests our argumentation.
Thank you, counsel. 1 minute, please.
Yes. 2 points for our rebuttal, members of the tribunal. Firstly, pertaining the issue of restitution. The respondent objected to the order of restitution or specific performance on the ground of Article 35, paragraph D of the RCWA as regards the disproportionate burden. However, we submit that they have understood the limitation of disproportionate burden here wrongly. They have understood disproportionate burden in terms of burden put on the host state in general. However, a close reading of Article 35, paragraph B would inform you that the burden here refers to whether or not the specific performance would be more burdensome as compared to compensation. Now, to order the respondent just to compensate the claimant only, we submit here would have equal weight to an order of compensation, and thus meeting the principle of restitutio in integrum, the very heart of Article 35 RCY itself.
Is that addressing the point that was being made against you, that to treat you differently to all other holders of licenses in a situation where that was no longer tenable in the light of EU regulations would be disproportionate, even though the ultimate outcome, so far as you were concerned, would be the same as receiving damages?
Yes, Mr. Arbitrator. Now, 2 points in that. Firstly, the issue there would be the enforceability of the award itself, not the possibility of the award. Now, as pertains to the enforceability, we dispute the fact that ordering such an award would run counter to EU regulation, and moreover, the difficulty in terms of enforcing the award should not be taken against the claimant, because the very situation of the difficulty here is one that the respondent has brought to itself by continuing to approve the 6,000 licenses, although they have realized they shouldn't, and by looking at the facts that they have in fact recognized that the scheme was a mistake. Therefore, it shouldn't be taken against the claimant as pertains to the difficulty. However, the strict proportionality remains that such an order would be proportional as compared to compensation. Now, very briefly, the second point of the rebuttal would be on the issue of which discount rate should be applied, the WACC or the COE. Now, under this point, the respondents submit that that has in fact been subtracted. However, we beg to differ, as if I may refer this tribunal to the problem version number 1. If you happen to have the problem version number 3, the problem version number 1 here, which contain the annex 4 of Professor Kovic, will include that in fact debt is included in the calculation. It has not yet been subtracted. Moreover, it is clear on page 48 of the record that the financing of the 12 projects come from both debt and equity. And according to the tribunal in CMS, in a situation where a project was financed through both debt and equity, the discount rate applied should be the WACC rather than the COE. Thank you very much.
Thank you. 2 minutes, please respond.
Members of the tribunal, we would also like to raise 2 points in our rebuttal. First of all, specific performance would in fact constitute an undue burden when compared to compensation, and this undue burden is precisely the violation of Article 18 of the Treaty on the Functioning of the European Union. If found liable, respondent submits that it would be indeed easier to compensate the investor rather than infuse itself in a never-ending cycle of accusations of non-discrimination based on nationality. And finally, as far as the second point of claimant is concerned and the repayment of debts regarding cash flows to equity, we would like to also point to Annex 4, page 2 of the record, where it is evident, members of the tribunal, that there is the word repayment included inside brackets, which means that debt has already been subtracted from the calculations. Unless there are no further questions, this concludes our arguments.
Thank you very much.
No questions.
All right. May I thank both sets of counsel very much for those very useful presentations to the tribunal, and we shall reserve our decision and deliver it as soon as possible.
Thank you.
Thank you very much.
Can I just stop you there? There will be So the tribunal has to deliberate, so I would ask everybody to leave the room. They will have to go to the Great Hall for the award ceremony. That's where the winners will be announced, and the reception to follow. You can leave.